teacher. I was a lawyer for 20 years, now I teach, and this mini lesson is to show you how I teach. In this mini lesson we're going to look at the law of tort, and there are lots of different kinds of tort, from assault to defamation to false imprisonment to bad professional advice, but the tort we're going to look at is the tort of negligence, which involves somebody accidentally causing injury, loss, damage or death to another person. And negligence is all about money. The whole purpose of the law of negligence is to give compensation for the victims of accidents. In ordinary English, negligence is another word for carelessness, and the key concept we're going to look at today is the duty of care in negligence. And if there's an ordinary English word for the duty of care in negligence, it is responsibility. So we're talking about the responsibility of Fred if he carelessly injures Bill. Now, in the House of Lords case of Caparo and Dickman, 1990 UKHL2, their lordships came up with a three-part test, a tripartite test, to decide whether, in a particular situation, Fred owes a duty of care to Bill. Now, the first part of that test is foreseeability. So how likely is it that Fred's actions would cause injury to Bill? It doesn't have to be more likely than not that Fred's actions might end up injuring Bill. In Page against Smith, UKHL 7, 1995, the House of Lords said that the risk had to be more than a mere possibility. It can't just be a fanciful, semi-imaginary thing. There has to be a solid possibility that it will result in injury. A factor in that is how serious the injury is likely to be if any injury occurs, because a relatively small likelihood of causing a very, very serious loss or injury or death or a nuclear explosion would be enough. The second part of the three-part test is proximity, otherwise known as the neighbour test. And this doesn't have anything to do with your the neighbourhood where you live or your family relationship with the victim. It's much broader than that. If, for example, you are a cafe and you sell food, then anybody to whom you might sell food is your neighbour, but also anybody who might end up eating the food that you've sold, they are also your neighbour. If you accidentally start a fire in a block of flats, then certainly the residents in that block of flats will be your neighbours for the purpose of this part of the three-part test. But also firemen will be, or even passers-by walking along the street who might be hit by debris. All of these people are your neighbours. And in a road accident, your neighbour is any other road user. Somebody who might be driving a car, crossing the road, perhaps even somebody who lives next to the road. All of these are people who you should have in reasonable contemplation when deciding how fast to drive your car. And the third part of the three-part test, we've had foreseeability, we've had proximity. The third part of the three-part test is fairness. Is it fair, just and reasonable in that situation that the court should impose a duty of care in negligence? In other words, that the court should make you legally liable to pay compensation if you injure somebody as a result of your carelessness. Now, we've got our three-part test, and it sounds almost like a scientific formula, but it really isn't. You cannot take a set of facts and, I mean, if you were an alien from another planet and you didn't know anything about our society, you could not take the three-part test and apply it to a set of facts and come up with a decision about whether or not a duty of care exists in that situation. Even the courts have said that these concepts, this three-part test, is elusive, fluid, obscuring and interchangeable. For example, in in the case of Stovian and Wise, another House of Lords case, 1996 UKHL 15, the proximity part was said to be the same thing as the fair, just and reasonable part. So I think they just do it to drive us crazy. Now, for a practical lawyer, it's not going to do you any good to sit down with a set of facts and apply the fair, just and reasonable test to it, the proximity test, the foreseeability test. It won't get you anywhere. So what do we actually do? Well, what we do is we look for a similar situation, and we look at what the courts have done in similar situations. Really, it's all about looking at the situation. Now, the factual situation that we're most familiar with in the law of negligence is going to be the road accident. And if we think about car drivers, the courts will almost always find that it was foreseeable that driving a car might result in injury, and they are almost always going to find that anybody who you have injured, unless perhaps it was a parachutist who landed in front of you, was your neighbour, because they should have been in your reasonable contemplation as somebody who might be hurt as a result of your carelessness. And the courts are also going to say that it would be fair, just and reasonable in a road accident to impose a duty of care, unless perhaps Fred was a bank robber and Bill was his getaway driver, something really strange like that. Now, I think one of the reasons for the fact that the court will always find a duty of care in negligence in a road accident is the universal availability of insurance. Car drivers are all insured, and if they're not, which would be about 8% of them, then the Motor Insurers Bureau, which is a voluntary organisation of insurers, will step in and pick up the tab if a car driver who was not insured is sued for negligence and the injuries that he caused. So road accidents are a situation in which the courts will always find somebody liable for their negligent acts. What about negligent omissions? I've got to say that the courts in England and Wales are much less enthusiastic about finding somebody liable for their negligent omissions, because that amounts to finding they had a duty of care to take positive action. Now, if somebody created the situation, they actually created the danger in the first place, for example by digging a hole in the road, then they cannot sit on their hands and expect the courts to feel that an Englishman's home is his castle and you shouldn't push people around. If you actually created the danger, the courts will find that you had a duty of care in negligence to anybody who you should have had in reasonable contemplation as being injured by that. And the classic example is the employer. Employers have workplaces. If the employer does not take action to replace broken light bulbs or to clean the floor, then in that situation, if somebody is injured as a result, the court will find that there was a duty of care owed by the employer to the employee. What if Fred sees Bill about to accidentally walk off a cliff, though? Now, there's no... it's certainly foreseeable that Fred would... it's certainly foreseeable by Fred that if Bill walks towards the cliff and falls off it, he will be very seriously injured. And you might also feel that it would be fair, just and reasonable in that case for Fred to be required to compensate poor old Bill if he walks off the cliff. But, or you might not. But the court will not find that there is any proximity between them. They will not find that Bill was Fred's neighbour for the purposes of this accident. What if Bill was visibly blind? What if he was wearing great thick dark glasses and carrying a white cane and tapping as he went along? Would Fred be liable for him then if he sees him walking towards the cliff? Does Fred owe Bill a duty of care in that situation? Is Fred responsible for him? Well, because we are English or Welsh and we have a particular attitude towards life, the answer is no. Unless Fred had in some way assumed responsibility for Bill, perhaps by giving him advice. Perhaps Bill said to him, "Hey, am I going right for the beach?" And Fred said to him, "Yes, you're absolutely fine, just keep on, you'll be fine." In that situation, the court might find that there is sufficient proximity and that it's fair, just and reasonable. So we then have each of the parts of the three-part test satisfied. What exactly is fair, just and reasonable? That's probably the trickiest part of the three-part test, and I think the answer can be found in cases about cricket, because in the 1950s cricket was seen as a wonderful manly sport involving cricket whites and cucumber sandwiches in the pavilion and the playing fields of Eton, and the courts wanted to encourage it. So if a lady was totally unexpectedly hit on the head by a cricket ball while walking down a suburban street, the courts would not find that a duty of care existed between the cricket club and the unfortunate victim. Even if there was a history of broken roof tiles, broken windows and dented cars in that street because of previous occasions when balls have been hit out of the ground. But if you come back 25 years later, so that was Bolton and Stone in 1951, but if you come back 25 years later and look at Miller and Jackson, very, very similar facts, and there the court decided that a duty of care was owed by the cricket club, a duty of care in negligence where it repeatedly caused injury by, or repeatedly caused accidents and damage by having cricket balls hit out of the ground. And I think what we're looking at there is a change in the court's attitudes towards social utility. Basically, the courts in 1977 were not so impressed by the social utility, the social value of cricket. Because I think we can always say that if, for example, somebody were somebody caused injury by shooting an air pistol at cats or by throwing stones at seagulls, and if that went over the roof of a house, landed in a suburban street and injured some lady passing by, no social utility. It's not an activity to which the court would feel sympathetic. So I think in that case we would certainly find that the fair, just and reasonable test was satisfied. So the practical solution in any case where you need to know if a duty of care in negligence exists in a particular situation is to go to the case law. The more case law you can access, the better. The more professional journals you can access, the better. And track down a case that looks like your case. And then you'll know what the courts will decide. Only after you've reached that conclusion is it worth applying the three-part test. And the situation where you're most likely to benefit from applying the three-part test in Caparo and Dickman, foreseeability, proximity and fairness, is in your exam paper. You do need to be able to apply that test there. You need to be able to analyse a case in terms of those tests. That's all in this demo lesson. I hope you enjoyed it.